we couldn't get my notes up this morning, so I'm kind of shooting from the hip this morning. So it looks like you're saying that there is a motion related to attorney's fees.
Yes, Your Honor.
All right, then. All right, let's go. You may proceed.
Okay. Your Honor, we came before the court back on September 13, 2023, when I filed a petition on behalf of my client, Ms. Reynolds, for a motion for an emergency hearing and an amended motion for contempt due to Mr. Williams' failure to return the child back to the physical custody of his mom after a visitation, based on false allegations of physical abuse. The court heard the evidence and concluded that that the court did not find at that moment that there was substantial proof of any physical that was done by the child, and as a result, the court entered an order denying the Mr. Williams' petition for family violence on September 25th. However, the court did want to make sure that the court thoroughly explored the alleged allegations, and so the court did also enter an order appointing a Garnett Lightem, however, at Mr. Williams' expense, and did find that Mr. Williams was in contempt. 30 days later, after Mr. Williams was notified that he'd be financially responsible for that Garnett Lightem, all of a sudden the allegations he agreed that the allegations were false. They were no longer true. He signed a consent motion asking the court to rescind its order appointing the Garnett Lightem, which the court did do on November 2023. And in the hearing back in September, the court did indicate from the bench that if their claims were found to be baseless, that the court would be entertaining attorney fees. And so that's why we're here this morning, Your Honor, because as a result, had I not gone through the extent of having to file this petition, bringing this issue before to the court's attention, Mr. Williams would have never returned his child back to the physical custody of Ms. Reynolds, as was the order of the court, as she is the primary physical custodian of the child. And as a result, she's had to incur attorney fees. And presently, her attorney fees are total $6,698.22. As part of my motion, Exhibit C, I did include her invoices from my office for October 2023 and November 2023, which total that amount, $6,698. Obviously, that does not include my time that I'm here before the court today, but I will waive that time. We're just asking for the $6,698. As far as my experience, I have been practicing for 14 years. In the area of family law, my hourly rate is $350 an hour, which is coming in appropriate for a person of my experience.
Can you put Exhibit C? Can you share Exhibit C? Let me see that.
Give me one moment. This is the beginning of Exhibit C, Your Honor. This is the invoice for October 15, 2023 from my office. And I'll scroll to the last page where you can see the total time and the amount.
This is beginning, you said beginning in October, but this is September. Were you excluding those, or this was the October billing statement?
The October bill for the time, for the dates in September.
Okay, so we're starting in September.
Correct, Your Honor.
All right, and this file right here was related to the emergency hearing only?
To the emergency hearing, the drafting of the orders, the communication with the Garnett Lightem, because she did communicate.
Can you go? Thank you. Can you go to the page?
Yes, Your Honor.
Just keep it right there for me, please.
Yes, Your Honor.
All right, thank you.
Okay. This is the November invoice for the dates in October. Okay. Stop sharing, Your Honor. Is that okay?
Yes. Yes, you can stop sharing.
And Your Honor, we're asking for attorney fees under OCGA 1962 as well as 91514, based on the fact that this was merely Mr. Williams' his attempt to try to navigate going through the process of requesting a modification of physical custody to try to get physical custody of his son and make these false allegations of court against my client. The claims that he admitted were false. He admitted that based on his notarized signature in the consent motion to rescind the Garnett item, that the
So
allegations.
they were once, you're saying?
I'm sorry, Your Honor.
Were they married at one?
They were married, Your Honor. There was a divorce that happened back in, let's see,
November of 21.
I have November 2022 on Your Honor.
2022, that's correct. I'm sorry.
Divorce.
Okay, all right, thank you. All right, Mr. Williams,
Yes, I first like to say that this was under no circumstances an attempt for custody for my son. The situation that arose, I did intercept returning him home due to things that came out from my child to me. It was directly told to me from my son. When I was getting ready to take him back, he was kicking and screaming, asking me, please don't send him back. During that time, I was already trying to figure out what was going on with the dynamics of our relationship because he had become distant and started telling me things like he didn't need me or a new family because I had moved on with my life. So I got him in counseling during that time, and that's when the things came out to the counselor. I submitted those notes to you from the counselor as well, and I didn't send him back in contempt, for that reason. However, you recommended that I send him back, or you were having a marshal pick him up. I've always complied with the court order, so I sent him back. The following week after he went back, when he came to me that following weekend, he then told me that everything that he told me prior to and told the counselor was a lie. And the whole time I'm asking him, are you sure that these things are happening? Because this is serious. Like, you can get both mommy and daddy into some serious situations. He was adamant on telling me these things happen, and his story never changed with me nor with the counselor. But when he came back after being home that first week and told me that everything was a lie, I was in disbelief. I sat the whole day asking him, why would you do this? It cost me my job. I lost my job October 11th. I have the termination letter from them as well to support that. And he just told me he didn't know why he did it.
Why son's story caused you to lose your job?
Because of I had just started this job. I was in transition with this position, and me missing work for the court hearings, they let me go because of me missing the trainings for it. I have that termination letter as well.
What court hearing did you, how did you, I don't remember.
So I had the video hearings, and though it would say 9 o'clock, I wouldn't be called on until like 11. So that time I was missing from my training. So they were saying because of me missing the trainings, I couldn't continue the employment. So I lost that. I'm sorry, ma'am.
How many hearings did you have that you missed that caused you to lose your job?
So it wasn't just the hearings. It was me going to file the proper paperwork. I had to take time off for everything that was going on with my son with that situation in itself. So it was the days that I missed from the whole thing overall.
Oh, okay. All right.
Yeah, and I lost that job. And then I called the mother and even apologized to her for that after he came and told me that he was making it up. I was very disappointed and hurt because, again, I'm not trying to create conflict or anything. And he said, well, I just thought that this was a way that I can come stay with you. And I said, I told you, son, that's not the way to go about doing things. You don't tell stories. You maintain your integrity. I kept asking you and telling you that this stuff can get mommy in trouble. You kept telling me that you were being honest. Why are you now telling me this? Did something happen when you went home? He said, no. I said, so why are you telling me now that you made this up? I don't know. Every time I ask him something, it's I don't know. So at that point, I did not see a reason to move forward regarding Malaita if he's now saying that these things didn't happen that I initially moved on because he was telling me that it was happening. I did not have effective communication at the time with the mother due to previous situations. So I humbly apologize to her for the mishap. Let her know what he told me. I also told her that I lost my job at that time, which around that same time, I got the notification for garnishment. And I told her, why are you doing that when I paid child support for a whole year with no issue? She told me I was already doing it in the beginning. So I'm kind of.
So your son admitted to you that he was not being truthful, that's the reason why you decided.
That's why I canceled the guardian ad litem. Yes, ma'am.
Ms. Reynolds, when your son came to visit to you, did he likewise acknowledge that he had lied to you?
No, because you told us to not mention anything pertaining to court or anything pertaining to the case with him, and I didn't. And so, so I didn't say anything to him about anything with court or anything like that. I just kind of tried to make it as normal as possible for him.
Yeah, but, and when he came.
So at what point Was there any point where you recognized that he had lied or discussed or handled the matter of him?
I mean, I knew that he was dishonest. I mean, because I didn't do those things, but I just told him, I at no point did I say anything in reference to court or anything like that. It was just telling him just be honest about things in life in general. But we didn't take anything about court at all because I didn't. And then I knew with the guardian ad litem in place and reading everything in reference to it, saying like any type of coercion will work against you. So I was very adamant about treading lightly when it came to that. So I didn't say anything to him about it. I guess he just decided to be honest on his own.
Yeah, if I can add to that, when I got him, he did come to me and say, "Dad, I want to talk." And I asked him, of course, I always give him my open policy. I said, "What you want to talk about?" It was very hard for him to talk to me and tell me what he did. He was kind of hesitant, but he did come out and say that he was not being honest. And again, I was disappointed and I just wanted to be sure. And I said, "So why did you go through this thing for a whole 2 weeks? Like you didn't want to talk to mom, like you were putting on these acts, like you were just scared to be around her. You saying these things about her. And I'm asking you, are you being truthful? Are you true?" And you're telling me that, yes, she even does it to your sister. Like you do all these things. And his only response to me was, "I don't know. I thought that it was going to keep you guys from arguing or that I was going to be able to come stay with you." And I said, "That's not the way that this goes. And you can't do stuff like this because now I'm in trouble and I'm looked at as something that I'm not because of this." But I appreciated him for coming forth and being honest. And I immediately called his mom that morning. I believe it was a Sunday morning. And I apologized to her for that because of what he came to me and said.
Okay.
He definitely told me when he came back from his dad that he did it because he felt like he had to. That's what his daddy wanted him to do. He did not say his dad made him do it, but he did say he felt pressured because he kept mentioning this really cool school and he thought that, saying that would get him to be able to go to that school. And he's like, "I don't really want to live with that. I just want to go to a new school," is what he said when he came back. And so, but I was telling him, how much that trouble that gets both of us in and costing
everybody.
Right. So
Yeah.
after he did the confession, I did have a conversation with him a little bit, but even still with the guardian ad litem still kind of hovering, I was also very gentle still because I was just like, I don't know, how much
parameters.
Yeah. So I just told him, I'm like, it's okay, Dan, I forgive you. We're going to move forward being honest and, whatever the case may be. Like, you just have to challenge yourself to not be dishonest. And we still kind of see him at times trying to play us against each other when we can. But I just kind of asked Mr. Williams in good faith that moving forward, if he does find that Jace is saying something contrary to what he knows and 18 years of us being together that I wouldn't do or that's outside of my character, that he at least address me or ask me first. Because when he called the cops on us, he never even called me. He never even let me know that you're like, "No, you're not getting our son back. He told us you've been abusing." He never gave me any heads up, any inkling, anything. So,
and that's our position, Your Honor. He took extreme measures
really quick.
And all of a sudden now he goes and stands for thing with belief.
No,
he tried to withdraw from school, everything.
If I can speak to this, Your Honor, in all honesty, this comes again. I'm not sure what her attorney stance is or what information she has, but this stems from a prior situation and watching how the relationship with my daughter was handled. Anything I would take to her, she would defend my daughter, and pretty much I would become the bad cop and she becomes the good cop. So nothing I said would be heard. And then now I have a situation where I have my daughter looking at me as doing something wrong when I'm just setting rules and boundaries to protect her. Whereas the mother is more so being a friend and allowing her to do everything. So when it comes down to communication with Miss Reynolds at times, I would always be put in a position of being the bad guy. So when these things came out, her and I weren't on good terms because of what was already going on with Jada, my oldest daughter. So when that happened, I took that into consideration, on top of the fact that I will be honest and say that this happened around the same time my oldest son passed away, September 20th. I received those same notifications around the same time. On October 11th was the day that I buried my son. That was the same day that I lost my job. Ms. Reynolds has been privy to everything from me being in the home, even outside of the home. So again, I try to keep communication with her as possible as I can, as much as I can. I can even submit text messages where the communication, it just wasn't going. And then again, the signs from my son coming over and the things I started observing when I tried to talk to her about it, she would denounce it. She would lie about things, even as far as opening my mail. So I did not feel that she would give me the truth or true information when it came down to him, because he had never displayed these behaviors before. Prior to him saying he wanted to stay with me, which was his, I never pressured him. I have a 6-year-old child that stays with me. And that little boy, you know, he is very excited about the school he goes to. So when my son is over, they get along very well. So they have their own conversations, and my son decided that he wanted to stay on his own terms. And I told him then, that's not the way it goes. If you want to stay, we have to go and talk to your mom first. And that has to be something that she agrees with. The initial conversation with her, she said, I don't think that you're ready for it. I think that school is too advanced. Let's revisit it next year. I was okay with revisiting it the next semester, as she stated. However, during that time, she went and started looking for another school for him to get into, because again, it's always been like a competition thing. As soon as he said he wanted to stay with me, then that's when the dynamics of our relationship started shifting, and he started saying things like he didn't need me, he didn't want a new family.
Go into the dynamics of your relationship, although it would not hurt y'all to do some type of co-parenting classes together, because
Yes,
that would be helpful to both of you. But here's how I see it. I do think that Mr. Williams, that I think the concern is it not necessarily that you brought those allegations, because you're a parent, a child brings something to you like that, you kind of must act on it.
that was my position.
Everybody understands that. The problem though is how you act on them. Like you should have called Ms. Reynolds first, you know, and try to figure it out. You've been with her for 18 years. You've never seen behavior like that in 18 years. I remember specifically asking you those sorts of things. So that should have been an anomaly to you. Like you should have understood that. But by the same token, as you indicated, you were going through a lot of trauma yourself. And so maybe you were not as rational as you should have been, because of the things that you were going through.
And she wasn't trustworthy at that time at all.
Well, it's not about trustworthy. It's about you doing what's right. And they're just certain parameters to go through. You can't start calling defects and all of those things, because those are highly responses. And so that's, you know, to some extent, that means that you are not responding appropriately when the first thing you do is jump to the highest level. There are different things that you should have done along the way. It may have prevented you from being in this predicament where you are right now. And so that was some of the concerns. And even taking the child to the therapy was outside of the parameters that you were supposed to go through. You could have come to the court. There were different things that you could have done before escalating as high as you did. Now, I do, like I said, I do recognize that your child brought something to you. You had to respond. My concern is how you responded and the escalation. It snowballed. It caused you to lose your job. It caused Ms. Reynolds almost $7,000 in attorney's fees. It caused your son to be in a position of, I mean, I don't know how much money you spent on the therapist, but you had to have the therapist. You had to pay money for the therapist, at least through your insurance. It's a lot to go on. And so you got to be careful about how you move when you have other people involved. Now, all that said, although I do believe that as a result of your response, it catapults us here, I do recognize that your son is the one who said it. Your son, he's both of your sons. Like, so yes. He's the one who kind of started it all. And, you know, to he did, because he's the one who told your dad, Mr. Williams, what he said was happening at his home. So we don't have, at this point, I haven't heard anything that indicates that he was coached to say that particular thing.
It's just one thing.
He was coached to indicate that he was lying. All I know is that right now your son made the allegation. And so to some extent, you're both kind of responsible because he's both of your son and he made those allegations. Right. So
text message, remember the text message, Judge Barrie? I don't know if you do, but the text message that he sent 1 week prior to this whole thing coming out, he said, when I told him that I didn't want to let him come live with him right now, he said, great, good, see you in court with the winky eye emoji.
It was not in reference to that, Larcenia.
I understand. That's not even a point. But 1 week later,
Ms. Reynolds, yes. I'm ruling.
This is crazy.
Mr. Williams, I'm ruling.
Yes.
Okay. Yes, ma'am. Yes, I do remember. I remember the particulars in the case. But what I'm saying to you though is he still went to a therapist, and the therapist interviewed him on several occasions, and he was feeding the therapist this information. And so I don't, and I don't, there's nothing to me that would suggest that he was coached. Now he may have, I mean, all parents have some influence over their child. Kids can read into what you want and will give you what you want, based on reading into you. And so those are natural children inclination. This is your child. This is the facade that he put how he put it on the plate, even though he might have been feeling the wrong information, even though he may have been thinking this is what Mr. Williams wanted and gave him the whole show. I don't know, but I do know that a third party interviewed him, and that is what he presented. So while I think Mr. Williams is responsible for these attorney's fees, I am going to give some consideration to the fact that your son did actively participate, and he's both of your sons. And I think, you know, if he had presented that way to you, Ms. Reynolds, I'm not saying you would have reacted in the same way, but if you would have been in court at some point, and those fees would have started accruing, if it was the other way around. So you have a person that's trying to do what's right by their kid, and it's both of your kids, and your kid is kind of facilitating, or not facilitating, but exaggerating those circumstances. And so I think you both have some responsibility in that. I'm going to take a moment to think about it. I will say, Mr. Williams, I don't want to leave you with this idea that these fields are going to be significantly reduced, but I will reduce them some. But I do think for the most part, the bulk of this is yours. But I do also recognize that the child is both of your responsibility. And he, at least to what I understand right now, based on the preponderance of the evidence, it sounds as if he was trying to give Mr. Williams what he wanted, and also trying to get to a different school. And so he just kind of made up these things, and here we are. That's kind of what now I do recognize, Ms. Reynolds, that, you know, there were these, you know, email, text messages out there that seem to suggest that this could have been a part of a plan or a scheme, and it could be something that the kid just picked up on. I'm not sure, but I do think that the bulk of these attorney's fees are Mr. Williams, but I don't think they all are. So I'll take a look at them, and then I'll let you know how I'm going to proceed. All right. Thank you so much, y'all. Take care.
One last thing. There is an outstanding motion for an income deduction order that we filed back in October based on Mr. Williams' inconsistent child support payment.
Well, Mr. Reynolds, Ms. Reynolds, did I swear you in, Ms. Reynolds? Do you solemnly swear or affirm that the testimony about to give to the court is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay. Has Mr. Williams been inconsistent in his child support payments?
Yes, I haven't. I received $200 in October for the month of September, and I haven't received any payments since.
And Your Honor, that is due to everything.
I think one of the things he's indicated, he had lost his job. Are there any issues that you had prior to him losing his job?
Yes. He started his order in January of 2023. He paid every month until June. In the month of June, he gave my daughter money directly, a little bit of birthday money, and did not pay child support to me. And then in July, he paid for June. And then in August, he paid for July. So he stayed a month behind until, again, which makes me feel away, on September, he paid and got caught up on August the 31st, which then 1 week later is when we had this court stuff. So, and then I haven't received anything since. So he said he paid on time for 12 months, but that isn't true.
Your Honor, if I can speak to that, I had no issues paying anything on time. In June, that is true. I sent money to my daughter directly because she did start reaching out to me. However, my car broke down in July, in which I told her that I was behind on my payment, but I would catch up. She told me, okay, no problem. I've always paid within that month, though it wasn't on that time that I normally would pay her within that 2 weeks. And then in August, like she said, I caught up for July's payment, but I lost my job in October, and in September, I was using money to file fees and everything else. So that's where the money was going to when I was not in communication, and I communicated immediately after losing my job. I've kept communication anytime the payment wasn't coming. I've kept records for myself and receipts. I sent everything through Zelle, so I always keep receipts and note what's due next and what I owe. I'm aware that I am still behind, and I told her as soon as I get a job, which I'm in training right now as I'm in court. I'm actually on online training. I just started yesterday for the new position that I have, which I'm making almost $20,000 less than what I was making at the time of the order. But I've kept communication with Ms. Reynolds the entire time, so she hasn't been oblivious to anything that's been going on with me.
When did you start the new job?
Yesterday.
Oh, okay.
But he told me
I'm literally in my first day of training.
But
Where's your new job, Mr. Williams?
I work online.
he told me like before my birthday that he started with the church and that when
That's volunteer work. I told you I'm volunteering.
That's
I
not
did not tell you I work for a church. I said I volunteer at church.
Mr. Williams.
Yes, ma'am.
All right. What were you saying, Ms. Reynolds?
Yeah, so on the 20, I can't remember the exact date, but he told me that he was just starting a new position, that he was in training, which is why we had like some legal issues trying to figure out visitation for December, because it doesn't specifically say how our break is supposed to go. And so I was asking him, can I get these weeks and you get these? He was like, no, it's my time. So needless to say, when it was time to get him, he said he started training and that he was going to let me keep Jace the first week of Christmas and he'll get him the second week because he started training. And I said, okay. So that was where we were.
So, and
Okay.
regard
Training at the church.
So you're saying that he works at the church?
I mean, that's what he told me that. And Jace, I mean, that's what he told me that himself, that he was working doing like a revival and some other stuff is why he couldn't get Jace. And so he was like, I just started and I have to finish the training and I'm planning to catch up. I sent him a text message saying that the payments weren't received. That's when he told me he lost his job. He didn't tell me right when he lost his job, but he did tell me in December that he hadn't worked since the whole thing took place with Jace. And I was like,
monthly child support payments.
pardon me?
How much are child support payments?
They're set for $465.
Oh, and they've been
for
set
both children
since January.
Yes, ma'am.
yes, ma'am.
Because you gave him a year of grace because he was saying he was unemployed and homeless, and you had his payment set much higher.
A year of grace.
Yeah, I recommend that you set it down. And then he was like, he could pay $300. You said, no, that's too low. Then you set it at $465 and told me that I could bring it back up a year after giving him time to get on his feet. And I don't know if you remember that or not, but I was cool with that.
Original job had changed, so the income had changed for that job. And so, but it sounds like now he's making less than it was previously.
Yeah, I don't know that to be true or not, because he didn't show proof then either. So
okay.
And Your Honor, the child support worksheet indicates $461. That's
$461. I'm sorry.
Yeah. Okay. All right.
Yeah.
Thank you. All right.
Your Honor, may I speak to that, please?
Speak to what?
The working in the church thing. I told her I'm volunteering at a church. So I told her I was still looking for work, but me volunteering in church had nothing to do with me making money. That was me letting her know that this is what I have going on. I'm still looking for work, but as soon as I get something, I will resume payments. I have all those text messages as well to support.
How much are you behind?
Right now, I haven't been able to pay everything since September. So it's about $1,500 if I'm not mistaken. But with me having this job, I should be able to catch up with the payments as resumed because I'll be working full time.
And what's the name of your new employer?
It's Ultimate Medical Academy.
What is it?
Ultimate Medical Academy.
Okay. I'll take it on advisement.
Thank you, Your Honor.
All right. Thank you so much. Y'all take care.
Okay, I'm ready.
All right. You may proceed.
Thank you, Judge. Brooke Graham here on behalf of Georgia Power, and we're here for Georgia Power's motion for summary judgment on all of Ms. Inyaga's claims. This is a fairly straightforward case. All of Ms. Inyaga's claims are based on the allegation that tree trimming work that Georgia Power did on property that she owns in DeKalb County was outside the scope of the expressed easement that Georgia Power has. Plaintiff does not dispute that Georgia Power has an express easement on the property. The easement's dated 1916, and so it's been on the property for a very long time. The express easement, and I'll just read a portion of it, gives Georgia Power the right to go in and upon said tract of land to construct, operate, and maintain perpetually upon said right-of-way its lines for transmitting electric current with poles, wires, and other necessary apparatus and appliances, together with the right at all times to enter upon said premise for the purpose of inspecting the said lines, making repairs, renewals, and alterations thereon, together with the right to cut away and keep clear of said transmission lines all trees and other like obstructions that may now or hereafter in any way interfere or be likely to interfere with the proper operation of the transmission line.
Miss Graham, do you have that available so that you can share screen on it?
I can certainly get it available. I'm happy to do that.
Okay, if you can't share screen on it very quickly, that way I don't have to switch between the file. But if it's going to cause a problem, don't worry about it.
I have an electronic copy of the summary judgment and the undisputed facts, and it's attached to it, so I should be able to grab it pretty quickly.
Okay, thank you.
Is the court able to see the PDF that I have up? I'm getting it to the easement. I just wanted to make sure.
Yes.
Okay.
Yeah, that's it. That's, I think. That's it.
Yes, ma'am. So this is the easement language that I was just reading.
Okay.
And it is not disputed by any party that Georgia Power has this express easement, and it dates back to 1916. Georgia Power additionally submitted evidence to show its historical maintenance of the easement area. So under Georgia law, if there's no defined width in a express easement, the court looks to the historical maintenance and the area that Georgia Power has operated under as to establish the width of the easement. And so in addition, with our statement of undisputed facts, we provided a variety of different evidence, an affidavit from a Georgia Power employee, Georgia Power brush surveys, which is what Georgia Power's maintenance uses to show the easement areas on certain property, and other Georgia Power records showing that since Georgia Power was granted the easement in 1916, there has been 100-foot width, 50 feet on either side of the middle of the transmission line, has been historically maintained for the operation of this transmission line. There have been times, and the affidavit says that sometimes Georgia Power maintained as much as 100 feet each time it went and maintained. Sometimes it maintained 76 feet. But over 100 years, Georgia Power has historically maintained a 100-foot right-of-way on the entire transmission line, not just the portion that goes over Miss Inyaga's property. In 2008, when Miss Inyaga purchased the property, she had a survey done. Miss Inyaga's survey says that Georgia Power's transmission line is 100 feet wide. Additionally, Miss Inyaga testified in her deposition that it was her understanding when she purchased the property in 2008 that Georgia Power had a 100-foot wide transmission line easement on the property, and that she did not dispute that it was a 100-foot wide transmission line easement. So all of the evidence shows that Georgia Power has a 100-foot wide transmission line on the property, and that transmission line easement gives Georgia Power the right to do many things, including keeping clear trees and other obstructions they may now or hereafter in any way interfere or be likely to interfere with the proper operation of the line.
Ms. Graham, can you hold on for one moment, please?
Of course. Complaint of conduct relates to either January and February of 2021. The allegations of the complaint claim that Georgia Power went on the property and cleared an area outside of the easement. Miss Inyaga, throughout this matter, has claimed, contrary to the survey, that she thought it was maybe 25 feet on either side of the transmission line. But in fact, Georgia Power cleared the easement area in the same way it has been doing since it got the express easement and within the area that it is permitted to do. And so because Georgia Power was operating within the scope of the express easement, and that's just simply undisputed, Georgia Power cannot be liable to plaintiff for any of her claims based on this. And that is the Heron versus Mitchell EMC case, which is 323 Georgia App 517. And it's cited in our motion. And that case essentially says if the complained of conduct is authorized by an easement, express or otherwise, and here we have an express easement, then there can be no liability by the utility to plaintiff for claims like trespass or nuisance or damages. And here that is simply the case. Georgia Power submitted their undisputed evidence and facts supporting with the evidence that I just kind of went through. We did not get a response to the statement of undisputed facts or a counter undisputed fact filing, though Ms. Inyagaga did file a response to the motion. Her response to the motion does not contain any admissible evidence to show that Georgia Power did not historically maintain this easement area with 100 feet width and was not operating within that historical maintenance in January or February of 2021 at the time of the complaint of conduct. In fact, in Ms. Inyaga's deposition, she admitted she had no knowledge of any of the historical maintenance prior to 2008 when she purchased the property. She had no pictures associated with the property or that easement area from 2019 to the present. Ms. Inyagaga does not live on the property. It's a vacant piece of land. And she testified that she didn't know how often she went out to the property since the purchase in 2008 to the present, and testified that she didn't really have any knowledge about the trees out there and whether perhaps it looks more full or less full in the winter versus the summer. And so all the undisputed evidence shows that Georgia Power's tree trimming activity in early 2021 was within the scope of the express easement, and so it cannot be liable for damages. Georgia Power also put forth a second argument in the motion for summary judgment. The second argument is, even if Georgia Power was outside the scope of the easement, which again, it was not, that plaintiff has not set forth any evidence of causation or damages. We sent written discovery. We also had a deposition of Ms. Inyagaga, and the sole basis for her monetary damage is approximately $110,000 that she claims is based on an appraisal that Ms. Inyagaga did. Ms. Inyagaga said that she did the appraisal as an independent person and not as an appraiser, even though she has an appraisal license because she was connected to the property. The problem is she bases it on an appraisal that was done in March 2021 after the complaint of conduct. The March 2021 appraisal appraises the property as the exact same as Ms. Inyagaga appraised it in July of 2019. And so there is no difference, even assuming Georgia Power was operating outside the easement, that any conduct actually damaged or caused any monetary damage to the property or to Ms. Inyagaga. Again, this is a secondary argument, just as belts and suspenders to show that the other elements were not met as well. And with that, I welcome the court's questions, and I will reserve any additional time to reply to Ms. Inyaga's argument.
Before we do that, how much area are you anticipating they did trim? What area, how much feet did they go into the area?
So the easement area has historically been maintained at 100 feet. Though, again, it varies at times. There may have been times historically that there was only the need to clear 76 feet on either side of the transmission line. Here, all they did was clear within the easement area. They removed no trees, and they did not go outside the easement area at all. And that's in the affidavit. I think we submitted 2 affidavits of John Balcom.
No, what I'm asking
one was with our motion to dismiss, and then another with this particular motion, that no trees were even, while we maintain we could have under the express easement, there were no trees removed off of Ms. Inyaga's property during that complained of time. Rather, essentially what happens is grass grows, and you're on a regular maintenance schedule, and you go and you clear off that grass and, you know, bushes and things of that nature when you're going and maintaining the transmission line. You trim up kind of the sides, and there may have been branches trimmed, but there were no trees removed in the easement area, again, despite that there's an express grant of that right. So in January of 2021, it was within the same area that has historically been maintained across Ms. Inyaga's property.
What I was asking, though, was in consideration, do you know how much of that? I know you're saying you're within the 100 feet, but how much of that did you do the whole entire 100 feet, 76 feet, 50 feet, 25 feet? What did you do?
I understand. I'm sorry, I misunderstood your question, Judge. I want to make sure I accurately stated, and I believe it is in Mr. Balcom's affidavit, and that is what I'm trying to pull up right now. As he spoke about the historical maintenance as well as here we go.
The actual.
Yes,
okay.
ma'am. There we go. Let's see.
I think it is. even though we're closer to 50 feet. Okay, I see.
Yeah, it looks like that it was within the historical right of way and did not expand outside 50 feet on either side of the transmission line on her property. And he also went through, if you look at paragraph 10, you can kind of get a sense of what kind of maintenance we're talking about. It's on a rotation. Sometimes it's just herbicide treatment, which there's a case, the Will and Properties case expressly discusses that. But sometimes it's tree trimming work. There's kind of a maintenance schedule that he outlines, the things that are done. And so it's not every year, right? Especially if you're not going out to the property a lot. It might, it might come across as a surprise because it's on a maintenance rotation of different types of things that have to be done to maintain the easement area.
All right, thank you. One moment.
Yes, thank you, Your Honor. First of all, Your Honor, I purchased that property in 2008. And when I purchased that property, it was visible that there was a 230K transmission pole within the easement behind my property. So the question is not that there is a 100-foot easement on my property. That's never been an issue. The issue has always been the fact that Georgia Power has not been historically maintaining that 100-foot easement. Because if they had been maintaining the 100-foot easement, I would have been able to verify that. And I would have noticed that between 2008 and 2019. Historically, Georgia Power, since I bought that property in 2008, Georgia Power has always sent me a postcard as notification, letting me know that they would be in the easement area for maintenance. Anytime they did major maintenance within that easement, they always notified me. I had no issue with Georgia Power between 2008 and 2019, which I had been notified approximately 2 to 3 times, and they had gone in to maintain it. And anytime they went in to maintain that easement, I would always go approximately 26 months after the fact, because they would send a postcard approximately 6 months prior to the maintenance of their easement. And also, Your Honor, I maintained the right-of-way of my property for years until DeKalb County started maintaining it. My property is on the corner lot, and there's a stop sign there. And because of the neighbors being able to see around that stop sign, I always maintained my right-of-way. So it is untrue that council has stated that I didn't visit my property. My property is in Smoke Rise. I'm only 10 or 15 minutes. I'm in Norcross. I'm not far from my property. So I do occasionally visit my property. When I purchased that property, Your Honor, I purchased that property based on the fact that the easement was being maintained to a satisfactory condition where when I build my home, that it would not affect my home. And I could see visually that the easement area was not 100 foot. It was not being maintained. It wasn't that open. It was a very narrow area that was being maintained. Prior to my purchase of the property, it was the same. It was overgrown. It was, it was just the same area they had been maintaining. They had been maintaining that property, from my knowledge, from the day I bought that property and prior to when I bought it. I have photographs. When Georgia Power requested an amended easement from me, and when they requested to expand their easement rights, they sent me a request with a settlement amount of $14,800 back in May of 2019, before all of this took place. And when I received that request from Georgia Power in May of 2019, before all this happened, like I said, I had no problem with the maintenance of the easement. They had been maintaining that easement. They had cleared it while I was there. When I received the request from them, it's when I was asking questions before signing the documents, and that's when all the confusion started. They decided they did not want to answer any of my questions. They did not want to provide to me any proof. The Bush survey that she's speaking in terms of, I was told that Bush survey was just a survey of the area, that it was not a maintenance record. My former attorney and I kept asking for the maintenance records itself, and they kept saying that the only thing they had to provide to us was a Bush survey, and my attorney asked for historical data from them, but they kept giving us this Bush survey, which is not a—
Ms. Graham, are you objecting? Because I can't hear you.
Yes, I do. I didn't want to interrupt, but I do want to object. Any discussions about resolution or settlement are not permissible as evidence on whether or not somebody may or may not be liable. And I mean, she's talking about her prior attorney and discussions on resolution of her issues. And we put an objection in our reply because that was a lot of things that she wrote in her response. And I just want to make an objection for the record that OCGA 24408 does not permit evidence or discussions of resolution of the claims to be admissible to prove liability or the validity of any claim. And I just want to state that for the record, and that's what she was discussing right there.
I agree. All right, you cannot do that. You can't discuss settlement resolutions. They're you can't present them to the court because, of course, public policies, we want to encourage settlement, but we don't want people to have to discuss what people may or may have admitted during settlement. So if you would stay away from that, unless there's an exception you want to bring to the court's attention.
Oh, I couldn't hear you. Are you speaking with me, Your Honor? Okay.
Yes,
Am
you
I
didn't hear what I just
my turn to speak?
Yes,
I'm
did you
sorry.
hear what?
Yes, I heard what you said, Your Honor.
Oh, okay.
Can I continue, Your Honor?
Yes.
Okay. And also, when counsel was interpreting the easement from 1916, what she did not read to you was that at the end of that easement, it clearly states that any timber cut on said of way by said company shall remain the property of the owner undersigned, and that the owner should be compensated for any. And also, what she did not read to you is that in the easement, it says that it gives them language, handwritten language. And the handwritten language says, if companies shall pay all damages done to the lands or growing crops of the underside by the company's forces during the construction or operation of said line. It is understood that this right-of-way is to be used only for a transition line. One erupt with 6 wooden poles for support. It talks about that. And it speaks also on the survey. It also speaks on the subdivision plat that any timber removed off of said land should be compensated by the person that removes it. So therefore, if there had not been any timber on that land to be removed, why is it in the easement that any timber cut on said land should be the company shall remain property of the undersigned, that the owner should not? And also it says that by force, that the land should not be disturbed by force. Also, Your Honor, I would like to point out the fact that I have direct evidence. I have knowledge. I have history. I've owned that property since 2008. The property easement area was being maintained. It was nice. One of the reasons I bought that property was because the easement was being maintained in a beautiful manner. It wasn't very open.
I'm confused with regard to what you're saying. I thought, and I understand that dynamics change. I thought that taking timber outside the easement area, was that not your initial position?
Oh, I couldn't hear you because it was a pause. I couldn't hear a pause on my end. What was your question?
What was your initial position that they had cut down trees outside of the easement area? Was that not your first position?
No, ma'am. My position is the trees that were cut down were cut. The trees that's in question that were cut down were within the easement. Now, they did encroach outside of the easement by cutting branches, and all that's in writing. Everything is in the emails. There's an email trail. Okay. There are photographs.
Miss Inyaga, let me make sure I understand, because okay. Either you're sounding inconsistent to me or I'm missing something.
Okay.
Initially, I thought your position was that they had cut down trees outside of what you believe to be the easement area. And I didn't think you were telling me it was 100 feet. But you're saying that you always understood it to be 100 feet and that they cut down trees outside of that 100 feet.
What I'm saying, Your Honor, is that the survey that I had performed, there's 100 feet drawn on the survey. I don't know how they got the 100-foot easement, because it wasn't within the original easement, but it was drawn on the subdivision plat. They drew 100 on there, and the language, there's 100-foot drawn on the survey that I had done. Now, I had not seen, when I purchased that property, I had not seen the survey from the subdivision, nor had I seen the easements in writing. I got those after I was contacted by Georgia Power. What I'm saying is that I don't know. I'm not saying that they don't have a 100-foot easement. I'm assuming that the subdivision plat established the 100-foot easement by putting it on there. But according to the subdivision plat and according to the written easement, they had not been clearing the whole 100-foot. If they had been clearing the whole 100-foot.
So yes, your position isn't that they cut trees outside of the easement. Your position is that they were not maintaining the easement?
My position, yes, Your Honor, is that they had not been maintaining 50 feet on either side of the transmission pole. They had been maintaining 25 feet on either side. So they had been maintaining a total of 50 feet. So now that they wanted to.
And so now that you're saying that historically, your position is that they were not maintaining 100 feet. They were only maintaining about 50 feet.
Yes, Your Honor.
And so now that they want to maintain 100 feet, you're bothered by that.
They've already cleared the 100 feet that they asked me for, that I did not agree to. When, you know, the document they sent me asking for them to be able to do that, I didn't agree to it because I had questions, and they didn't want to answer my questions. So they took it up on themselves in January of 2021 to clear it anyway without my permission. And now that they cleared it,
I just said they already had an easement. So if they already have an easement, why do they need your permission?
they had not been clearing the whole easement. And according to the easement agreement, it states that when you go in to open it up to the other 50 feet, you have to compensate the owner for that. That changes the appearance and everything about the easement is totally different now. It's not the same
Okay,
easement.
put the easement back up and tell me where you're saying where it says if you go back in that you can't. Okay,
Well,
so
actually what it says is that any timber cut, what I meant to say, Your Honor, is that any timber cut on said, anytime you go in to cut timber or make changes to the easement area, because and even in order to amend an easement, you cannot amend an easement with just one person. And that's why Georgia Power sent me a request in 2019. They did the right thing when they sent me that request.
Miss Inyaga, I need for you to take a position because I'm confused. Your position is that, and I asked you from the beginning, was it your position that they did not have 100 feet on or 50 feet on either side of the pole? And initially I thought your position was they did not, that you thought they had less easement area than and that they were cutting trees outside of that easement area. Now it seems to me that you're saying, no, they're within the easement area, but they were not maintaining it. And when they did cut the trees, they should still have paid you for them. Is that what you're saying?
Your Honor, what I'm saying is that the only thing I can verify to you today is that I was aware that they had been maintaining an easement on my property to the extent of 55 feet on either side of the transmission pole, because I measured the easement area they had been maintaining in 2019 after I met with a couple of the employees and representatives from Georgia Power. I took my tape measure and I measured. I didn't have a problem with the 100-foot easement because I saw it on the subdivision plat. The problem of this whole case is about maintenance. The maintenance and the trees that were cut down. It's not about, there's no dispute that there is a 100-foot easement that's showing up on the subdivision plat.
All right, so tell me about what portion of this easement right here that you're saying is causing you a problem. Point that out to me so I can understand what you're saying.
Okay, the problem that's causing the problem for me, the easement, the easement agreement itself, the writing, the handwritten language, it says the company shall pay all damages due to the lands. The handwritten underneath the typewritten language, the handwritten language.
Read what you say, what you're saying. I want you to read it.
Okay, it says said company shall pay all damages done to the lands or growing crops of the undersigned by the company's force during the construction or operation of said line. It is understood that this right-of-way is to be used only for a transmission line, reenact with wooden poles as support for wires, and that not more than 6 of said poles shall be placed on said property. It is further agreed that said company shall not cut or injure a certain walnut tree standing on said lands near said right-of-way. And that's where the walnut tree comes in at. It was in the easement agreement, and they said that it was standing close to the right-of-way. And
so it was cut down?
Georgia Power hasn't been able to point out. I've asked Georgia Power about the walnut tree, and they haven't. Doing discovery, I received nothing pretty much from Georgia Power as far as evidence in the defense. And I had even actually sent a motion in to reopen discovery back in February of last year during the sanction hearing. I had a motion on file, but I was told by the court that the court would not hear the motion because I didn't bring it up at the sanction hearing, which I didn't know I was supposed to bring it up for that.
But before, Ms. Graham, go back to the document again. Position is that anytime they maintain the property, they're supposed to pay you for the brush that they take off the property.
No, Your Honor. That's not what I'm saying. No, ma'am. No, Your Honor.
What are they paying you for then?
They sent over, the document is on file. There's a request that they sent me. Let's see what does it say? I can read it to you. They sent me
This is
document.
related to attempts to resolve these issues. Again, just for the record, Judge, I just want to make sure my objection's clear.
You cannot present anything related to the attempt to resolve it. Now, if you're talking about something before the trial started or before the matter started, that's one thing, but you cannot show me what they offered you during. Okay.
Before the trial started, before I filed the lawsuit. Before the lawsuit was filed, I was trying to work with Georgia Power. Georgia Power sent me a request to amend 2 easements on my property. Okay. They sent me the request to amend the 2. I said that was not a problem for me. Let me research it and make sure. And when they sent me that request, they sent me a copy of the easement agreement from 1916. I had not seen that easement agreement because my closing attorney didn't submit it to me, which is not an issue for me. But when they sent me the request in 2019, in the request, it was explained to me that they wanted to not acquire more easement area, but that they wanted to maintain the easement area that they had not been maintaining historically. And I was told that verbally and in writing.
Okay, so, let me see the document. Let me see that document.
Well, I don't know how to put everything. It's emails. I've submitted so many emails.
Where did you submit that document? I can look it up.
Let's see, the one that I have so many papers on my phone here. Which document is it that you're regarding, Your Honor?
Well, the one that you said was they were requesting to extend the easement bigger than you said that they originally had.
Well, I'm not saying that they wanted to extend the easement. What I'm saying is that they wanted to maintain. They had been maintaining 25 feet on either side of the transmission pole.
Okay. So they wanted to pay you to maintain it?
No, ma'am. No, Your Honor. They wanted to pay me to amend the easements that are there, and they wanted to take out all the language as far as paying and compensating. They sent me the easement that they sent me. It's there. Let's see. You have it.
Tell me where. You have a lot of documents here. So tell me where am I?
Let's see. Okay.
So is it in your response?
Yes, Your Honor.
Okay, what page on your response?
Okay, let me see which one it is.
Okay, you got the I'm looking at your July 3rd filing of your motion opposition.
Exhibit A1. And Exhibit A2. Exhibit A2 it shows the calculations of the area within the easement that they were trying to maintain.
Okay, give me a second. Let me just let this populate on my computer. It's moving slow. So give me a second.
I pulled it up with her notations. I don't mind sharing my screen. She'll have to tell me where to go, Judge, but I pulled up her response and the notice of filing A1 through A4.
Yes, pull that up. Pull that one
That's
up.
what I just pulled up. I can share my screen.
Okay, share your screen.
That's an easement itself. I'm speaking, yes.
Okay, this one?
Okay, it's that was when I received the request from them. A2, Ms. Graham, if you would pull up A2 up, that shows the calculations. Your Honor, this is the email.
This is the one that they sent you saying they want to pay you.
Well, the one that she just, that one is where they said the $14,800. That's where they said they wanted to pay me to clear the 50 feet on each side.
Okay, let me read. Okay, let me read this. Okay, got it. All right. And so your position is that because they had not initially cleared that line, they wanted to now clear it, and they were going to pay you for clearing the portion that they had not originally cleared.
Yes, Your Honor.
Got it. Okay, I see. All right. And go to that that letter above this one. All right, let me see this.
Sorry, I'm sorry. I'm trying to get it to where it's a good.
That's fine, right? That's good. That's good. All right, now can you go one more time, Ms. Graham, and pull up that old easement, please, the original 1916 easement?
Yes, ma'am.
Okay, I see what you're saying. All right, continue.
Okay, Your Honor. And so therefore, Your Honor, I have direct knowledge and history. And also, counsel has stated a number of untrue facts, stating that I said that I knew that Georgia Power had been clearing 100 feet of an easement. That's totally incorrect, Your Honor. I have, during the discovery period, I have presented all of the emails, photos, I've even sent in an affidavit attached to my opposition, stating to you all that I have no knowledge of John Beckham, which is the tree arborist that wrote the affidavit. However, I did have direct contact with a tree arborist person, because at the time that this took place, Mr. John was not, the person that wrote the affidavit on behalf of the defendant, he was not available. So they had another employee in his place, and that's the employee that I had contact with. That's the employee that I met on the property, and that's the employee that explained to me that they had not been maintaining the whole easement area, and they wanted to go ahead and maintain the whole area.
Okay. Now, you just told me earlier, I just want to make sure I understand, because I thought you told me earlier that you measured how much they had been maintaining, and you agreed that they had been maintaining 50 on each side.
No, Your Honor, I said that after this whole incident happened, and after I received a request from them, and I met with several of their employees. At that time, around that time, I decided to measure, before they even cleared it, this is in 2019, I decided to measure the easement area that had been maintained, and that was when I came up with the 25 feet on either side of the transmission line.
Oh, I see what you're saying. Your position was, before they came out, you looked at what they had traditionally maintained, and it was your position that it was 25 feet on each line.
Your Honor, from 2008 until 2021, the same area had been maintained.
The 25 feet each side.
Yes, Your Honor. The easement
and your position is, at some point, they sent you a letter and said, although we've been maintaining 25 feet, we know we can maintain up to 50 feet. We haven't. We want to clear that, and we're going to pay you for clearing it.
Yes, Your Honor.
And then at some point, before you could agree on it, they cut it down anyway. Is that what you're saying?
Well, before I could agree with them, when I started asking questions, then they stopped communicating with me. And they said that they would continue to just maintain the area that they had been maintaining. And I was okay with that. But when I went out there,
they did more.
Yes, Your Honor. But when I went out there, so I received a postcard from them in 2020 saying they were going to be out there like they've always done. And when I went out there early 2021 to verify, like I've always done, that's when I noticed that they had opened it up to the whole 100-foot, which had changed the appearance of the easement.
Okay, I see what you're saying. Okay. I see what you're saying. All right, now I have an understanding why what you're saying. All right, thank you. So once you realized that they had changed the appearance, then you said you tried to contact them, and you said they stopped communication.
Well, I tried communicating with them before it took place from 2019. I tried communicating with them. I asked for someone in the legal department to speak with me. No one would. And so I had to hire an attorney to be able to speak with them. When I hired
reiterate my objection for the record, Judge Barrie. I just want to make it super clear that I object to any of this discussion during the discussions about all of this. I'll address the substance of it just for clarity's sake in my reply time, but I just really want to make sure it's clear for the record that I'm objecting to any kind of discussions about resolution of this, because it's just barred by the statute. But again, I just want to make sure I'm not waiving anything.
Yes, and I don't. So, Ms. Inyaga, you got to be careful about not mentioning it, but I also don't want to take away from her ability to tell the story. So we're gonna have to play some of it by ear. If it gets to a point where she's saying too much, I'll stop her. All right, go ahead.
Okay, so Your Honor, because she keeps okay, I'm gonna have to rethink my thoughts, because when I get interrupted, my thoughts, I have to remember where I don't remember. I have to remember where I stopped from.
Okay, get your pen and notebook so you can write it down when you get stopped.
Okay, thank you, Your Honor. I think where I was. Okay, so I had to hire an attorney in order for me to get a conversation or to have my questions answered by the Georgia Power attorneys. I had to hire my own attorney. I hired my attorney. He wrote a letter to the Georgia Power attorney on staff, the staff attorney over there, and we had a Zoom call with the attorneys. And in the meantime, before that happened, my attorney and I went out to my property and we counted those tree stumps within the easement area that had been cut down. So I was there with my attorney. I took the photos and he counted the tree stumps. Okay, after that, we had a Zoom meeting and my attorney said to them that we were looking for a more historical record to show the easement area prior to 2008. Because when I bought the property in 2008, it was clearly the same way as prior to when they purchased it in 2000 from the subdivision community. So once I have photographs So what happened was, once I received the request from Georgia Power in 2019, and I met a few people, and the discrepancies, red flags started appearing. So I started taking photographs. So the photographs that I took were from 2019, before they went in 2021. I started taking photographs, and I documented the way the property was when I purchased it up until when I started taking the photos in 2019. It had not changed. So I took the photos. So I do have photographs, before and after photographs, Your Honor.
Where are the files?
I could hear, Your Honor.
Where are those in your exhibit files?
The photographs are in my motion. The photographs are in the motion from the defendant. They attached the photograph.
Huh?
The photographs were attached. The photographs are attached to the Georgia Power Statement of Undisputed Material Facts. And my photographs are.
I'm happy to pull those up, Judge. They are attached to our motion.
Okay, I'll note up. You don't have to pull it up right now. I'll make it a note.
And they're also attached to my my motion, all of my discovery. You didn't get the discovery, but it's also, yes, Your Honor, they are attached. And I don't think that that's Your Honor, the photos attached to the defendant's undisputed material statement of fact. Those are not all the photos. Those are mostly the treat. These were the photos that were attached, I think, during the deposition that they may have attached, but there are before and after photos that clearly shows the condition and the state of the property before January, February of 2021. And after speaking with Mr. John Beckham,
why did you put them in your reply?
Because I guess, Your Honor, because I have put them in, I think they were attached to the motion to dismiss. I've submitted, it's like a lot, it's Your Honor, there are many pictures that I've submitted during discovery, and I'm almost sure they were attached to my motion to dismiss. But I could email the photos over real quick. I have them here on my computer.
Anything else?
Yes, Your Honor. And so the only thing I'm saying here is that I do have relevant evidence. I have physical evidence. I have documentary. I have a lot of documentary evidence, and I have personal knowledge prior to the actions that took place in January, February of 2021.
All right, Ms. Brown.
Yes, Judge. I wanted to address a few of the things raised by Ms. Inya-Aga. First, as it relates to, and I'll just go back to, just so everyone knows what I'm looking at. It's the same documents we talked about that Ms. Inya-Aga directed your attention to. And it is a communication from a land agent at Georgia Power, and then an email. And
right.
As a practical matter, the email says we are not acquiring any additional easement or right of way from your property. We are just defining it, since the old easement was not specific. There's no testimony from anyone. I don't know that any of Ms. Inya-Aga's view of what she thought this meant is admissible evidence. They speak for themselves. But as a practical matter, when Georgia Power has older easements, it is very common practice to say, hey, let me get a defined easement and I'm willing to pay you additional for it. I'm not really asking for any additional right of way, which is exactly what they said. We are not acquiring any additional easement or right of way from your property. We're just asking that you define it, and we're offering to compensate you for that. Ms. Inya-Aga chose not to do that, and that's fine. But that should not be used as some sort of, well, you used to have a 100-foot easement, and I agree with that, but the fact that you at some point were asking me to help define it somehow means that your subsequent activity was incorrect. There's actually a case on point on this issue. And it's about what it takes to abandon an easement as it relates to non-use. We believe all the evidence is super clear. I'll give you the case. Yes.
Yeah,
I wanted to give you the full citation.
I'm not looking at the additional easement requirement or abandonment. I don't think that's initially, that's what I was understanding her to mean. But now I have a better understanding what Ms. Inya-Aga is saying. Her position is that she's looking at a particular position in the easement and reading it differently than what you're reading it. Her position is, if you go to it, it says that if you're going to clear land that's going to force injury to the land for your maintenance of the land and or for your operation of the property, then you will pay for that. And then you have a letter basically indicating the same. it says essentially, we are not expanding our easement. We believe we already have 100 feet, but we recognize that because we have not cleared it and we now want to clear it, we're going to pay you for any injury or damages as a result. And her position is, when you look at the pictures, you can see that there are differences in the property of what was generally maintained and needed for the operation than what is necessary for the operation of it now. So she specifically, if you recall, I asked her, what are you looking at so that I can better understand you? And she pointed to that first line where it says that the company shall pay all damages done to the land, not just for the construction of it, but also the operation of it. And to the extent that they're indicating that for the proper operation of this line, they need to clear and force, i.e. by taking down trees and crops and any other thing that might be in the way of it, then they will pay for it. And I think that is her position, although initially I didn't understand that to be her position. Whether that morphed or it changed, that is her position now. And that is that's a reasonable position to take. So I'm trying to figure out, why do you believe it's unreasonable?
Sure. So, okay. And I'm happy to answer that question, Judge. It's really two reasons. One,
okay.
The express easement gives Georgia Power the right to keep clear trees and other obstructions that may now or hereafter in any way interfere or be likely to interfere with the proper operation of the same. And the way Georgia law works is, if you don't have a defined width, you look at the historical maintenance of the easement. Ms. Inyaga has no knowledge of the historical maintenance of the easement prior to 2008. That she admits that. She didn't own the property. She had no exposure to the property for 90 years. All of the evidence shows that the property was historically maintained at 100 feet on either side of the center line. Ms. Inyaga agrees that when she purchased the property, there was a 100, and I have up the document now, the survey that was done in 2008 says 100 feet Georgia Power easement. The affidavit testimony says that this is what Georgia Power has historically done. Additionally, and again, I just want to reiterate that comments that Ms. Inyaga makes as part of argument isn't evidence. And so we have sworn testimony as well.
What comment?
And we have just her oral argument here. It's not what she said in her deposition. I don't have any measuring tape situation from 2019. There's no measurements. And so I just want to show a few clips from her deposition about what we do and don't know, since she did own the property in 2008. Prior 90 years, there's no evidence that she can combat what Georgia Power historically did. She purchased the property in 2008. There's the 100-foot survey. She told me she did not recall every single year how many times she visited the property.
Miss Graham, but that goes against your own letter. No matter what she said, your letter specifically indicates that you have not maintained the property and that you want to go in and do so. Go back to that letter.
I would disagree. It says that we're not acquiring any additional easement or right of way from your property. We are just defining it, since the old easement was not specific. It is common practice.
Go to the sentence above that. It says GPC is offering $14,000 to clear the 50 feet. That's what they're offering the money for. They didn't offer the money for a right of way. They were very clear. We're not offering you money for the right of way. Their position is, we're offering you the money so that we can clear 50 feet on each side of that. So why are they offering the money if they have already continuously cleared it and that's what they've been maintaining? It's inconsistent. That doesn't make any sense. If I have already cleared the land and I keep it clear, and that's what I've been historically doing for 90 years, why in 2019 am I going to ask to clear something I've already cleared?
And sure, and that's what I was explaining earlier, and what the next sentence is explaining as well, which is, it is an undefined easement. And it is very common when we have old easements on properties to go back and say, hey, we want to get a defined easement. So it's super clear. We don't have to have this historical maintenance, this discussion we're having, and we'll get a defined easement and we'll offer to pay you money for it. We are not asking for additional easement rights. We have the easement we need. We are just asking if you want to enter into a defined easement. And she said no. And Georgia Power proceeded to clear, as it historically had done, And that's what the evidence shows. When asked about whether trees were removed, let's see, all of these pictures of tree stumps that she claimed were removed, I specifically asked her, do you know if this tree stump is located on your property? And she said she did not know. When asked about the walnut tree, and I'm just trying to make sure I can pull it up. I mean, here, when asked about whether she took any surveys or measurements, I did not think it was necessary for me to do all that. This is just, and this is sworn testimony. This is from her deposition. And all of these sites are in our, she does not have any photos prior to 2019. So there's really no anything from 2008 to 2019. And so, and the actual evidence is that Georgia Power did not remove any trees located on her property on this date. And she cannot prove otherwise. Her testimony is she did not know. When asked about the walnut tree, she did not know. When asked about the tree stumps that she took a picture of that she claimed were removed from her property, she said she did not know if that was her property or not. And so not only are there factual statements that are just not disputed despite oral argument otherwise, the fact that Georgia Power was seeking to define and update an old easement is not evidence that Georgia Power's historical maintenance is not consistent with what they did in January of 2021. Georgia Power had an express easement dating back to 1916. The Willen Properties case is really clear that just because, even if Georgia Power had not maintained it exactly consistent 100 feet every single time, even if Georgia Power only maintained it once every 3 or 4 years, and so perhaps at the end of the cycle, it didn't look like it was maintained 50 feet on either side, but they go through and they do their clearance activity, and it does. The Willen Properties case, and that's 321 Georgia App 297, is very clear that the timing and the extent of the periodic maintenance is not sufficient evidence of non-use to change what the express easement provides. And in Willen Properties, I believe they were actually putting in new, bigger poles with bigger arms, and the court said that was sufficient under the easement.
I don't think you understand what I can now understand. I'm not talking about the easement. I think everybody is clear. You have, at least her position is, and so I don't have any reason to doubt between the two of you, that there's 100 feet of on the either side. I mean, for the easement. What her point is that we're not saying you don't have the right to clear it. We're not saying you don't have the right to alter it. We're not saying you don't have the right to go in and do whatever's necessary. But there's a provision in that easement that says when you do, if it says shall pay for all damages done to the land or growing by the company's forces during the operation of said line. So the question becomes, was there damages or would there be damage done to the land for your operation of it? And I don't know if you're saying that I don't know if there is a clear answer to that, but that concerns me if it is her position that for the 20 or how many years that she had the property about 13. For the 13 years that she's had the property, and when she bought the property, it looked one way. And then when they went in and cleared the easement to the extent that they're permitted to do, it now looks another way. I don't know that to be the case. And I'm not saying one way or the other, but I don't know if you're answering the question on that sentence. What does that sentence mean?
Okay. And I just want to be really clear. It's just very different than the complaints allegations. And so if we are all in agreement that Georgia Power has a 100-foot easement and has the right to do all of that, and that we're not disputing that anymore, we're not back to the 25 on either side, I'll move on from that. So I just want to make sure.
Like you're saying, because initially, Graham, I was with you. I thought her position was that they had gone outside of what she believed to be 25 feet on either side, and that they had cleared land that was outside of the easement. That's what I initially thought Ms. Aga was saying. Now she's saying something else. So I don't know if it's morphed or if she has found another position to take, which of course she has a right to do that. But what I'm dealing with right now is what her argument is right now. And her argument right now, when I specifically asked her, what are you looking at? Are you indicating that if they maintain the property and during the operation, that maintenance of the property could cause damage to the property? And her position is yes. And she points to this sentence. I don't know if it's, I am not stating it is wrong or right, because I have not reviewed the motions that you have put down. We have done my staff has done an outline of it, which is what I review. Then I go back and review it myself. And I haven't done that. So I haven't read those cases that you're specifically outlining. I will, however, do so. All I'm saying,
I can answer your question.
He's making. And so I want you to tell me that. So when I'm reviewing, I can keep in my head the arguments that are being made and the responses.
Okay, so if we are talking about this first paragraph about paying damage to the land or growing crops during the construction or operation of the line, that would be like if there was a home and a driveway, and in accessing the easement area, the driveway got cracked. If when the initial clearing was done back in the 1920s, there were crops there, or there was actually timber, that would be compensated for. That is what that means. The express easement gives us the right to do the tree trimming activities. And to the extent if a tree is removed, so that's what that means. I mean, it means if we actually damage, and of course, if we had done that, we will, I mean, I'm going to be real candid. Had Georgia Power, if they were out there maintaining it and Miss Inyaga had a driveway and they ran over the driveway and there was a crack in the driveway, that would be damage to the property associated with the maintenance and the construction of the line. But this is not in the easement area. We are given the rights that are right here. And that includes clearing the trees, etc. And if we damage the land otherwise while trying to maintain and operate that line, that is something that under the easement, Georgia Power would be a damage, right? A cracked driveway. There's many of different things you could think of, but that's just not what we're talking about. The complaint of activity is tree trimming within what everyone agrees. Now that I understand, everyone agrees Georgia Power has the right to be in and the right to do. And under the law, we cannot be liable for doing something we are allowed to do by an express easement, which is the case here. To the extent she is complaining that, I'm sorry.
I said, okay, I hear you. Mm-hmm.
And to the extent she is complaining that trees were removed in the easement area and that she needs compensation for that, her deposition test. So I will be very clear. Our investigation showed no trees were removed. I have an affidavit from someone saying that. There were trees removed on a piece of property next to hers, and that is where the pictures of her stumps are located. And in her deposition, and that's what our affidavit says, in her deposition, when I showed her the pictures of the tree stumps that she provided to me, she said she did not know if they were on her property or not. I specifically asked about the walnut tree. Where was the walnut tree? Do you think that was removed from your property by Georgia Power in 2021? And she said she did not know. And so there's no evidence that trees were removed from the easement area, that even if this sentence was talking about that there was damage associated with. But that's not what this sentence is talking about. And to the extent Ms. Inyaga is relying on the communications from 2019, where Georgia Power says, we're not trying to get more easement. We're just trying to bring this old easement and update it and have a defined width, and we're willing to pay you for it. That is not somehow an admission that what Georgia Power did in 2021 was not within the easement area. All that is Georgia Power trying to get a 1916 easement more modern. There's a variety of reasons unrelated to this that you would do that. Back then, you didn't use the communications fiber language. I mean, there's a lot of reasons to bring more modern easements. But again, that's not evidence that what happened in 2021 somehow violated any historical maintenance and was outside the scope of the easement, which says that trees and other obstructions can be removed. And so, I would just ask the court to look at the motions and the evidence. If you have additional questions, we're certainly happy to answer it. But it's just simply not disputed with evidence in a genuine way that Georgia Power did anything wrong and outside the scope of their easement in January of 2021. and we moved for summary judgment, and this was the time for Ms. Inyaga to set forth anything disputing that.
I have a question for you. You're saying you have not seen any pictures that shows a difference between the property before the 2019 entry and now. So there's nothing that you've seen that says this is what the property looked like before she's making her argument, I guess before the 2019 clearing. Is that what I'm understanding?
So she said she did not have any photos prior to 2019. This is her deposition testimony. She produced photographs, and I cannot recall exactly when, that were maybe in the spring of 2020 or 2019. This is prior to 2019. So she did produce some photographs that were in the spring of 2019, 2020. And then she produced photographs that were in February of 2021. And then she produced photographs in June of 2021. And frankly, the June 2021 pictures and the 2019 pictures look very similar because it's spring and the trees don't have leaves everywhere and they're not all falling off and all the ground isn't brown because it's winter. And so her testimony is that she did not take measurements. She did not think it was necessary for her to do all that. I mean, I specifically said, so the only, I mean.
When was the cutting? The clearing?
The clearing took place in, I believe, January of 2021.
And your position is the spring 2019 pictures look like the June of 2021 pictures?
Yes,
Similar.
and that's in our motion where we attach and just kind of say, and I asked her about that in the deposition. That's also attached to our motion, which is, do you have any knowledge about trees and why it may look more full and different in 2021 than it does in 2020? But also, Judge, as a practical matter, and this is in John Balcom's affidavit, these maintenance are on cycles. And so it occurs about every 3 or 4 years. And so right before the maintenance activity occurs, it's going to look different than right after. That's the point of the maintenance activity, right? Is to go in there and clear it and make sure everything's clear. And so I'm not going to say that the right-of-way 3 years right before it was about to be cleared doesn't look different than right after it was cleared. I mean, that's the point of the maintenance, is to keep it clear. And John Balcom's affidavit explains that rotation for this piece of property and what was done looking back at the evidence.
All right, thank you. I think I have what I need. I'm going to take it under advisement. I'll review the documentation that you all presented to the court, okay?
Thank you, Judge.
Your Honor.
Yes.
Yes, Your Honor. Like I said, I do have many photos. I have photographs taken from 2019 before the project took place, the actions took place, and I have photographs after the actions took place. And you can clearly see that the easement area is totally different from when I first purchased the easement area.
All right, thank you so much. Y'all are free to leave.
Is my voice coming through good? This is my old PC here.
Yeah, I can hear you.
Right,
I have a sore throat, so I apologize if I start cracking, but I'll do my best.
Oh, you sound good. All right, are y'all ready?
Yeah, as long as my carrier doesn't wake up, it'll be good.
Okay, well, I hope he stays asleep then. All right, go ahead.
Okay, so I'm Alexa Corton. I'm here on behalf of Sandra Cooper, the petitioner in this case. We are here just to ask that Ms. Whittington be ordered to pay Ms. Cooper's attorney's fees in the amount of $16,601.26. That is for the contempt and modification action, and we're asking for those fees under a combination of 1993G, which provides for attorney's fees in a child custody action, or 1962, which provides for fees in a contempt action arising out of a divorce. There's no possible way to separate out which fees were related to both, because realistically in this action, the modification was needed due to the contempt. So really they're all just kind of the same in terms of what fees were what. I have submitted my attorney's fees affidavit and invoices detailing each and every charge beginning in October of 2021 when I first took this case. So it was a very lengthy contempt and modification case. We started attempting to resolve these issues in October of 2021 and went all the way through today in 2024. So my billing statements are all the way through the end of 2023. It does not include about 2 hours of preparation time and today's hearing. So we would like to tender my affidavit as to reasonable attorney's fees as Petitioner's Exhibit 3.
Yeah, I don't object.
I sent that over to Ms. Marshall.
Exhibit 3. Okay.
Yes. There was extensive communication during this case, numerous attempts to settle both before and after the filing of this action, and an abundance of further issues throughout the litigation. We had a mediation. We eventually had the trial on March 14th that lasted over 9 hours, which resulted in Ms. Whittington being held in contempt of court for numerous actions in violation of the party's parenting plan and a modification of the parenting plan to make it even more flexible for Ms. Cooper and give her a tiebreaker for extracurricular activities. So we would like to tender our order holding Ms. Whittington in contempt as Petitioner's Exhibit 1 and the new parenting plan as Petitioner's Exhibit 2.
Yeah, no objections, already part of the court record.
Yeah.
Okay.
As you probably just read in your notes, you found that Ms. Whittington was nasty and overly rigid when it benefited her, was not acting in the best interest of the minor children or in the spirit of how the court intended for the parenting plan to work. She purposely had Ms. Cooper banned from attending the children's kindergarten graduation, refused rightful parenting time on numerous occasions, refused to provide car seats for the children's transports, and refused to list Mrs. Cooper as the other parent on the forms at the children's school, among other things. Despite all of this behavior on the part of Ms. Whittington, Ms. Cooper actively tried to settle before filing and throughout this case, but was met with absolutely no compromise from Mrs. Whittington and nasty responses, if any. We sent over a very reasonable proposal offering to dismiss the very real contempt issues in hopes of making the parenting plan more clear and to settle this case amicably. We were met with no reasonable attempts of settlement at all. Ms. Whittington called off the mediation without any good faith effort on her part. We're hopeful that a financial consequence.
I'm sorry, what'd you say, Ms. Horton?
Ms. Whittington called off mediation without any good faith effort of settlement on her part.
So there was no mediation?
No, we mediated for a couple of hours, but we would have kept going and trying, and she said no more.
Okay.
We're hopeful that a financial consequence in the way of attorney's fees may actually guide Ms. Whittington's behavior in the right direction, as unfortunately, thus far, since the court's finding of contempt, it has not helped, and there have been more and more issues since that hearing. And we're concerned that if Ms. Whittington doesn't feel the impact of her actions, she will never stop her behavior. Mrs. Cooper is paying child support to Ms. Whittington as well as her other daughter's mother, and is also paying for travel expenses to visit these children in Texas very regularly. This case has an enormous negative financial impact on her, despite these issues being out of her control. Ms. Whittington is an able-bodied working woman and receiving child support. She's more than able to pay these expenses, and she should have to, since absent her behavior, none of this would have been necessary. We are open to a reasonable payment plan. And once again, we're asking for that $16,601.
What does the reasonable plan payment plan look like?
We would take anywhere from $500 to $1,000 a month until it's paid off. We do want to make sure that it is paid off, and so we need her to set up those as some type of an automatic payment or something like that. But we are open to that. And I accept payment via Zelle, via certified funds, via whatever she wants. That's all I have, Your Honor.
Thank you. Mr. Shaw?
Yeah, first off, a lump sum award, just because that's the entire fee that have been billed, is not authorized by Georgia courts. You have to first figure out, for example, 915-14, which she isn't asking for fees from, and she isn't entitled to because she wasn't a separate motion filed, which is required. You have to bifurcate what fees are through the negative behavior and what fees are not negative behavior. You can't just say I billed $20,000, so I should get that. And her argument was mostly a 915-14 argument, arguing bad faith and bad behavior on my client's part, and concluding that she, for example, had bad faith mediation. But what she didn't bring up, for example, is the issue of adoption of the children. That was that was something they were requesting. My client was saying no way. And so her characterization of bad faith mediation, there's no evidence support. Both sides had their issues that they got hung up.
You said what was happening?
Yeah, Ms. Cooper, this goes way back to 2021, I think, maybe 2022, wanted to adopt the children as well. And Ms. Whittington was not in agreement to having that take place. And so they had different issues that hung up attempts at settlement. And they both had legitimate reasons and issues for why they couldn't reach settlement, which happens in these cases all the time.
So Cooper versus Cooper, they were not married?
No, they were married. So an adoption is not necessary, but that is still something that Ms. Cooper wanted. And you could see it back in or Ms. Corton's billing statements. There's even back in 2022, there's even entries inquiring about adoption on her billing statements. Let's see, did I write down the specific date of that? Well, I could find it for you. Scrolling's a bit of a problem, but I'll get there. And adoption is brought up at least twice in her billing statements. And maybe Ms. Corton knows when that was. I think I'm almost there though.
I don't off the top of my head. I'm not disputing that we requested that as part of negotiations. It wasn't a hinging factor.
Yeah, and that's subject to interpretation. My memory isn't perfect, but I know that was an issue my client was adamantly against, and they brought it up a couple times. I don't recall if that was a point or not, if they conceded on it or not. I don't remember all that stuff, but that was one of several issues. And it's also something that she's billing for that she wants my client to reimburse her for.
How much did I bill for that?
That I don't know. It wasn't that huge of a billing statement. It was just specifically mentioned, but that's the sort of thing that I believe is built into a lot of the fees that are being billed. Because the complaint was drafted in April of 2022, was filed in May of 2022, and then the trial was in March. The final order was put in place in May of 2023. And if you look at her billing breakout, she does have April and March are the two big billing statements, and I don't have any problems with what she billed on those dates. Those were heavy dates of 2023. But if you look at her statements, which are on page 3 of her exhibit 3, she substantially billed money well before any complaint was even drafted. And then she billed more money, at least she didn't put past July on her fees. And there's I think May 23 is fine, but like June and July, they're talking about other issues that happened that have not been filed for future contempts, if they exist, which I don't know if they will or not. I've talked to my client about that only a little bit. So you have fees from October 2021 up to the date of April 2022, which are talking about a whole bunch of things. And she didn't even filed a complaint to April of 2022. So I think any of the fees incurred from March of 2022 before to October 21 shouldn't even be included in the calculation. Those are before
Give me
the
that.
filed.
Give me that. Give me. Hold on one quick second. Come on. Give me 1 second. I'm sorry. That's the only thing about this digital notebook. Sometimes it freezes on you. Okay, give me those dates again.
October 21 through March of 2022 are all pre-filing her complaint.
Okay.
And that's 23, 26. It's about $2,900 something, $3,000 right there. And then the fees from May 23 to July 23, which is $550 or $600, should not be included as well.
Okay.
All right.
Did you add that up as well?
I will do that once I get done with this. I got to take a second to do it right now.
Your Honor, to be clear, the charges leading up to the filing of the case were all us trying to resolve the contempt issues prior to filing the case.
Okay.
So I would argue those should absolutely be included.
I'm just taking down his notes. You'll have an opportunity. This is what
Thank you.
And those are, as she admits, those are contempt issues. That would be a 915-14 or 96-2 issue if they're contempt. Under 96-2, you have to take into account the relative financial status of the parties. And Ms. Cooper makes substantially more money than my client does, who makes $64,000 a year as a professor at her college. And under 196-2, without making findings that there's some need for her that makes it necessary to be subsidized for her attorney's fees, there isn't any grounds to award her attorney fees under 19-6-2. And the contempt is 915-14, which isn't even being alleged in this argument. And so that leaves 19-9-3. And the parties both had legitimate reasons for what they wanted out of the modification of custody. I do believe that Ms. Cooper won on many of the issues. She got some more power in regards to extracurricular activity, and there was some clarification, for example, in the car seats and things of that nature. But physical custody didn't change, legal custody didn't change, and it was more just making the plan more flexible. I think that was in your order, actually, or at least that's my notes from what you said from the bench. And then you drafted that order up. And I don't think it's fair and equitable. Yes, my client did end up losing on some of those issues. But for example, during Thanksgiving, you found that Ms. Cooper was also being unreasonable. And you didn't award any of those expenses against my client because of that. So they both had issues. I won't deny that Ms. Whittington had more issues than Ms. Cooper, but that's what you have in a case. And what we're talking about here is parenting plan, not contempt. And that only leaves 19-9-3, which I think Ms. Cooper would be eligible for fees. And in that, I believe both parties in good faith had issues that they were contesting. And I remember I was really concerned on losing joint legal custody, which we didn't lose. And so I think they both had a good faith basis to contest the issues. And so my position is I'll calculate those other fees here just a second for you. But first, the total fees billed should not be as a lump sum. And second, my client should not be made to pay for all of her fees when both parties had legitimate bases and were fighting to keep what they had or to get a little bit more. But this isn't one of those cases where custody got transferred. And Your Honor, are you still there?
Generally, if I drink something, I turn off the video.
Okay, I'm sorry. Yeah, I know I've been lectured before not to take my diet due while I'm in your courtroom, so I've been disciplined.
Decorum. That means no driving, no drinking, no eating, no smoking, no lying in bed.
That's unlike a certain judge who I like and was retired in Fulton County. I won't go into that story, but that's what we are arguing. She shouldn't incur all the relevant fees, and she has less financial resources. And I know my opposing counselor knows better that 19-6-2, you have to put up financial information. And I think she's not putting it up, hoping I won't bring that issue up. But I believe she makes more. She can explain it. That's just what I think it is, because I believe she makes more than twice as much money as my client.
So your position, Ms. Cooper, makes twice as much?
Best guess. She may make a lot more. But I'm pretty confident that she makes more, materially more. That's the best I can actually say.
Okay.
Well, actually, I do have hold on. We do have the child support worksheet from the prior case. Let me pull that up. At the prior case, Ms. Cooper made $12,194 on the child support worksheet, and my client made $5,189 a month. She still makes approximately the same amount of money. I don't know if Ms. Cooper's income has declined, but it was more than twice as much at the divorce in 2019.
Okay.
So I'm asking for that each party pay their own fees. And if you do decide to make an award of attorney fees, to take into account first, it shouldn't be a lump sum of all the fees that have been billed, and my client should not be responsible equitably for all her fees, Your Honor. Thank you.
Okay. The Exhibit 3, the attorney's fees, was it attached to anything that was filed, or are those the ones in the Dropbox that Ms. Marshall has?
Oh, yeah, it's in the Dropbox.
Yeah, it's in the Dropbox.
Okay. So
May
Ms.
I
Marshall,
do a brief response?
yes, you can, but Ms. Marshall, just send me, I need Exhibit 3.
Sure.
All right, go ahead.
I'm sorry, Judge. Whose Dropbox is it, and when did they send it?
It's in mine, which was sent yesterday. Around.
Yes,
thank you. And you need P3, is that correct, Judge?
Yes.
3.
Thank you.
Okay, you may respond.
Just very briefly, 1962, it does mention that within, fees are to be determined when the sound discretion of the court. Yes, the court shall consider the financial circumstances of both parties, but that's not the only factor that's taken into account. Additionally, yes, my client does make a little bit, definitely makes more than Miss Whittington, we think. We don't actually have no idea how much Miss Whittington makes. Miss Cooper, how much do you make approximately?
Around $98,000 a year.
98,000 a year?
Mm-hmm.
Okay, and how many kids do you have total?
3.
You can put yourself back on mute. So, I mean, she doesn't make substantially more, but in addition to that, she pays child support to Miss Whittington. She pays child support to her other child's mother. And she pays all of her visitation related travel expenses to see these two children in Texas. So when it comes out, you know, she really doesn't have any more income. In fact, she likely has substantially less than Miss Whittington when it all comes out. On top of that, the second parent adoption wasn't a hinging factor. It was something we asked for in negotiations. And to be honest, the fact that Miss Whittington absolutely refused a second parent adoption, given the political climate at the time that we asked for it, just shows further that she doesn't consider Miss Cooper an equal parent. So I don't see how that's a super benefit to them. However, I did just search through my billing statements, and I don't quote me on my search feature, but I only saw 1.1 charge for $30 related to an adoption. I could be wrong if you saw something else, Attorney Shaw, but that's all I
No,
saw.
I didn't say I saw a substantial amount, but I think it's all intertwined in the fees that you billed in total because they're not all specified.
Sure. I did also want to specify that we never requested sole legal custody at any point, but legal custody did change. My client was given the extracurricular tiebreaker as part of this case.
Okay, so there was you did not ask for sole or legal or physical custody.
No, we asked for joint and some tie-breaking authority.
Yeah, it was just the final decision-making power that had me concerned in this case, not that she asked for sole legal custody.
Okay.
So, I mean, truly, we tried to be as reasonable as possible here, and we were not met with anything reasonable in return. And so, you know, when you look at both of these attorney's fees statutes, I think we qualify under both of them very clearly on both the contempt issues and the modification issues to get the vast majority, if not all, of the $16,000 of fees that my client spent here.
I would just add that my client's employment contract is in our Dropbox. It's the Whittington, MOA, and it shows $69.33 monthly salary, but that's over 9 months. That doesn't cover 12 months.
Okay. Does she work during the summer?
Sometimes she can. Sometimes, my understanding, sometimes there's work at the college for her, and sometimes there isn't. This year there wasn't, and she doesn't work any other type of job if it's not a teaching job available in the summer.
How old are the twins now?
Ooh, I don't remember.
Your Honor, can I speak?
Yeah. How old are they first?
They're 7. They're 7.
Okay. All right.
Can I just clarify really quick? As far as travel, she gets a discount or a reduction. You gave her a reduction in our first divorce filing to travel. So she gets a reduction and she gets parenting time. I know that Ms. Quarton had said she pays for all of it. And then the other thing I just wanted to clarify was the adoption was used as the only tool to try to get me to make changes to the plan. It wasn't like I could make, I agreed on some of the things.
I'm gonna stop. I don't want to end up having evidence from the both of you. I think your attorneys have already proffered what the issues are.
Actually, I do remember an offer letter like that. But I can't speak of how long or how hard they were on that point.
Right, and I can look at the billing statements on it, so we can kind of figure it out based upon that. Let me ask you, Mr. Shaw, specifically from what you recall, what were the winning points that you said Ms. Whittington won on?
Well, she won on, for example, for Thanksgiving, there was a pickup issue that you found that Ms. Cooper was unreasonable about. And she wanted her airfare and other things awarded. And it was something like she refused to take an Uber or something to get to the airport, something unreasonable. And also on legal custody, she mostly won because Ms. Cooper already had the power to choose one extracurricular activity. And that's something that you pretty much gave her, you just reiterated in a different way in the final order, as an example. And I believe the summer stayed at 6 weeks. And other than that, you clarified there was the 4 o'clock issue. And sometimes she was coming in at 8 o'clock. Now, my client didn't win in that issue because you made clear it wasn't reasonable for if she doesn't get there at 4 that she forfeits her visits. But it was a legitimate position for her to take, first practically because she does have her life she had to schedule. But second, on a contempt provision, that's what it said was 4. And she was arguing because it was ambiguous whether or not she could be able to do that. So on that issue, that stayed the same. He just basically clarified it and said, that's not reasonable. You don't do that again.
Okay. And the hearing that we had, was that on Zoom?
I believe it was, yes.
All right. Ms. Marshall, can you find me the my oral pronouncement on Zoom for this case? Send that to me as well. All right. Thanks so much. I'll take it on advisement.
All right. Thanks, Your Honor.
Thank you, Your Honor. We appreciate it.
I'm sorry, Your Honor. Do we know the date that we're looking for?
It was March, I believe, 14.
Yeah, that's when the hearing was, yeah.
March
Okay.
14 of 2023?
Yes.
Mhm.
I'm sorry, March 14th, 2023?
Yes. Let me just verify that.
Yeah, that's the date.
That's correct. Yeah. Okay.
Okay, Your Honor, and you're just
I did
looking
a very
for your
busy
ruling or the whole hearing?
Just my ruling.
Yes, ma'am.
Yeah, you had a very busy calendar that day. I remember like 6 or 7 hours we had to wait, but you got to us.
I tried. I'm sorry.
I felt like we were on for quite some time.
It was hotly contested with some surprises, to say the least.
So, all right. Thank you so
We're
much.
back
I'll
on
take care of
James versus
James.
All right, thanks, John.
You've all had an opportunity after the court pre-trial the matter. Tell me how we're proceeding.
Judge, my client is in agreement with moving forward with reunification therapy. We were talking about a potential therapist. We had not yet come to an agreement, but I have not yet heard from Mr. Meineke on his client's position.
Okay. Ms. Meineke.
Thank you, Your Honor. I've spoken with my client. I think that we are close to an agreement along the lines of what we discussed pre-trial. My client has concerns, and we didn't go into all of this in the pretrial, but the parties have settled all the other issues in the case, and she is currently paying $1,000 per month in child support. So she has $1,000 per month in child support. So she has concerns that if she's essentially going to have to turn around and spend probably close to that amount per month on therapy and individual and reunification therapy, that would be financially prohibitive. So
I understand that. Let me ask you with regard to, are we talking about without insurance? So there are no insurance involved in this matter?
Not for reunification therapists, Your Honor, not defined, and possibly for individual therapy, but reunification therapists generally do not take insurance. I will tell the court that she does have a $136 per month deviation on her child support and didn't actually pay any child support until I believe it was October of last year, through the entire year plus that dad had custody before that. The current reunification therapy order specifies that if dad goes to a session, because obviously the therapist likes to get both parties' perspective before beginning therapy, that dad would pay for his sessions, mom would pay for her sessions. They split the cost of the child's individual sessions, and then mom pays for the sessions with her and the child. We'd ask that continue. That's already in the consent order we issued a year ago, or that the court issued a year ago. So we'd ask that continue. At this point, dad's paid 100% of the child's expenses and didn't receive any child support until October of last year.
Okay, so with regard to the reunification therapy, how much money did Ms. James pay out on each session generally?
That I do not know.
$250 per session, Your Honor.
So she paid $250 per session. That's for her, or for her and her half for the child?
That was for her individual visits with the reunification counselor and the joint sessions between her and the minor child.
Okay. Now, before you just indicated that she would be paying close to, if following what I indicated would be the position of the court in the pretrial, that she would be paying close to $1,000 a month. Where are you getting that number from if we're talking $250 right here?
Well, my client's saying that the rates increased from $250 to $350 last year, but if she's doing individual therapy at the same time, even if they're doing 2 reunification visits per month, and then she does 2 individual counseling sessions per month, that's 4 sessions at $250 or so a piece.
Oh, she doesn't have insurance for her individual sessions?
She may have insurance that covers individual therapy, but the part of our discussion and the guardian's, position was that shouldn't be a consideration for mom in picking her therapist. So, that's something that we would certainly want to explore. But I also, most of the time, the types of therapists that are involved in these things do not take insurance.
Yeah, I can
thought
understand that. How much
I
money?
apologize. I thought the guardian's position was on the reunification therapist not having to be covered by insurance. I thought that was her position. I wasn't clear that her position was on individual therapy and insurance.
No, I think I indicated that I'd like for her to do individual therapy a few sessions before she starts the reunification. And I wasn't necessarily indicating they need to be simultaneously done. I think I specifically believe one should be done before the other. I'm not necessarily saying it has to stop, but I clearly want it to be done before the unification therapy first, so that, I think it'd be better for Ms. James to go into a session having a clear understanding of just her views and why she feels the way she does, so that when she goes into these individual therapy sessions, she'll be a better job articulating, her feelings, and also what she wants to kind of get out of those sessions. But let me back up just a little bit. How much money does she make a year?
Your Honor, I don't have her yearly in front of me, but her gross monthly income for purposes of child support is $14,235.66 per month.
All right. And 14,000 per month?
14,235. Yes, Your Honor.
All right. What does Ms. James do for a living?
Can you tell the court? You don't have to unmute, you can just speak up, because we'll use the speaker off of my computer.
Okay.
I am an insurance underwriter. I've been in this line of work for approximately 18 years.
Okay, insurance underwriter. Okay. All right then. So
may I add one additional caveat?
Uh-huh.
But prior to I started paying court mandated child support, I did financially contribute to Joshua's welfare, whether it be through paying for fees associated with school, sporting activities, and I've been very generous since the process has started from a financial standpoint, and communicating with the other parent on opportunities to split fees wherever possible for any activities that Joshua was involved with. And the other parent declined or did not give me an opportunity to financially support my son in that way. So to compensate for that, I purchased clothing, shoes, paid.
I don't understand why you're bringing that up. I don't even know where that's coming from. That is not my issue.
That was just, to, give a little bit more context on the fact that I've not been reluctant to contribute to Joshua's financial.
Yeah, I don't even know where you're getting that from. That's not a concern of mine. I never thought about it. Somebody may have said something, but if you listen to where I am, what I'm trying to do is come to a resolution with regard to the things that are outstanding. Your child support matter, you all have resolved all of those things. The only issue that's outstanding before me is the custody issue, and I'm not considering child support. So I'm not sure exactly what you heard that kind of made you feel the need to provide that additional information, but I can't do anything with what you just said based on what I'm thinking in my head. What I'm trying to do is figure out a way to preserve a relationship with your son. That's what I'm trying to do. And so I'm looking at what can we do to be able to do that, and whether or not, based on what I kind of laid out for everybody, if it's financially feasible to be able to do it. And of course, take care of your son as well. So that's kind of what I'm looking at. Mr. James, what do you make a year?
Your Honor, his gross is $16,000 a month.
Okay, so 14 and 16 a month. What do you do, Mr. James?
Hi, Your Honor. I'm an IT manager for a construction company.
IT manager. Okay. So what I'm trying to do is try to figure out the kind of the feasibility piece. So if Ms. James, I'm hoping Mr. Monarchy indicated to you what I would like for you to do is to do some individual sessions first. So I think those sessions might do better if you kind of go in with a different kind of just a more holistic view of kind of you and who you are and your relationship with your son, kind of already have that kind of worked out. And then so that when you go to those unification therapy, you can kind of focus on the relationship, because you've kind of already did some of the work with regard to, what responsibilities and accountability pieces that you might have to deal with. And then I'm hoping that that will make this unification period a lot smoother. I understand you've already gone through one. It didn't go as well as you would like, and that it was terminated. I think it's important for you to, of course, try again. And then throughout that process of trying to reunify with your son, we'll have some kind of little, not little, but kind of, they're kind of like nuggets along the way so that you can reestablish this relationship with your son. I think it's going to be very difficult for me to take a 16-year-old and kind of mandate him to have these, what we call general visitation, things of that nature. I think that'll be very difficult for me to do based upon what I've heard about the relationship and also his position. So I've gotten some of that information from Ms. White. It was superficial. I haven't gotten anything deep. Those are just kind of superficial positions that were taken for the court to have a general understanding and laying out what I would propose if I didn't hear all the evidence. So that's kind of what I'm looking at. You're saying that you would be unable to pay $1,000 plus the $500 a month for reunification.
That is correct, Your Honor. I subsidize the care and welfare for my elderly mother who lives in Mississippi.
Okay. So what were you doing before?
Pardon me, before I began.
What were you doing before? I understand you were already doing your reunification therapy before you stopped it, and you also had to pay child support. So how were you making it?
Oh, Your Honor, I was not paying child support last year during the time frame in which
Okay.
took place.
Oh, got it. I see now. Okay.
Judge, if I may, I've
Mhm.
got a copy of Ms. James's financial affidavit. Based on her financial affidavit, she's got a surplus of $4,000 a month.
And I don't know what's in the financial affidavit, Your Honor. That was prepared before I was involved in the case. So
I'm happy to share the screen, Your Honor. It's from the supplemental discovery I received from her attorney prior to mediation. She grosses
what time frame?
Your Honor, this was 9/25/2023 was the date I received it.
Oh, okay. Let me see it.
All right, yes, Your Honor. So this was the financial affidavit that I received in their supplemental discovery immediately prior to mediation. Ms. James lists her net monthly income at $10,119.70. And if you don't mind if I scroll quickly down to her expenses, her final expense figure is $6,193. It's about a $4,000 surplus on a monthly basis.
Okay.
I don't know that math is correct, Judge. I didn't prepare that. I haven't looked at it before now, so I don't know how to.
She verified it, Your Honor. She signed
I
it.
understand, but people make errors all the time, so I haven't had a chance to look at it. So
All right.
I don't know that that's correct, but.
Okay. Can I see your clients?
Mine, Your Honor?
Yes. Mhm.
It's not to say, Your Honor, that my client doesn't also have a surplus on a monthly basis. But truly, it's very minimal, about $300 based on the amount of taxes he's paying. So his net income is $97.82. His total monthly expenses are $94.66. A large chunk of his income is bonus income.
Huh?
A large chunk of his income is bonus income, which is why it's taxed so heavily, Your Honor.
Okay. That's a good chunk.
Yeah.
Go to the second page.
You sure?
Uh-huh.
And these are quite old figures, Your Honor. These are from July. And they do include Miss James's figures that we had at that time as well.
Okay, go to the next page.
Yes, ma'am.
Okay, right there.
Yes, Your Honor. Do you need to see his expenses as well?
Huh?
Did you need to see his monthly expenses?
Yes, I'll take a look at them. These are the ones you already put on the front that shows that he's got a balance. He's basically evening out.
Correct, Your Honor. These are just the broken out expenses for each of his monthly expenses and then his credit cards.
Mm-hmm. All right. Does the child go to any private schools or
He does not. He's in public school, Your Honor.
Public school. Okay.
Your Honor, I need to make an updated announcement. My while the court was going through some of those documents, my client indicated to me while we were muted that she no longer wished to contest custody. She wishes to resolve the case so that the parties can settle it. So that's what she's told me and instructed me to tell the court at this point in time. I have not had any discussions with Miss Lewis about what that parenting plan would entail. But if that's what my client's desire is to do at this point, I don't want to waste any more of the court's time, going through all of this.
Her position is she's not contesting custody, i.e. she doesn't want to go through reunification process, or she's saying she's not contesting custody. So that means
she will agree with Mr. James having custody of the child so that the parties can finalize the divorce and be done with the process.
The entire process, including the reunification process.
That's correct.
Okay.
I mean, she doesn't believe that she would be able to do the reunification. She just wants to be able to be done.
Okay.
I have some questions that maybe are more appropriate for settlement negotiations outside the presence of the court.
Yeah, and you all can do that. I just want to make sure Ms. James understands that the reunification process with a minor is probably your better opportunity or better chance to have a relationship with an adult person. Do you understand that?
I do. I have ongoing health issues that have continued to deteriorate, and for my own health preservation right now is why I have reached a decision to agree to the custody resolution. I had hoped that we could reach an agreement during mediation, and there just not been an opportunity for us to reach a compromise. I don't feel encouraged that resuming the reunification is going to result in any change of heart on the part of my son, unfortunately.
Well, you wouldn't know that until you've tried, but I understand if you got health issues, you can handle, you do what you need to do. But I think when you got to think, Ms. James, you're talking about a child.
Right.
And so he's trying to make these adult decisions. And he's in that middle ground where the court has to give consideration to some of the things that he wants, but that doesn't mean that they're all based rationally. And this is your opportunity to be able to think through some of those, some of the things that has happened in your relationship and resolve them. Because let me tell you, Ms. James, if you think that in 2 or 3 years that they're going to go away and that they're going to resolve on their own, they're not. They're always going to be there, and they're always going to be right on the surface, festering. Even if even if in a few years you start talking again, you're going to have to deal with whatever that caused that separation with you and your son. You're going to deal with it today or tomorrow or in the future, but it ain't going away. You have an opportunity to have a relationship with somebody, to start a relationship or to restart your relationship with somebody who's amenable in mind, because he's young. But if you let it fester, you don't know what you're going to get. I don't know if you want to take a moment to think through that or not before you call that, because it's a big deal, and I don't want you to throw it away because you're frustrated. But I'll let you make that decision because that, of course, is yours. I'm going to give you 5 minutes to think through it, and then if you guys want to go in the breakout room to resolve it, I'll let you do that. All right, Mr. Meinke, talk to your client.
Thank you.
Tim, I'm going to go into a breakout room with Mr. Meinke. I'll be right back. Ms. Marshall, if the judge is still available, we have an agreement that I'd like to just inform the judge of, and hopefully we can.
Okay, one moment. I'll let her know that. Oh, there's
Thank you, ma'am.
I'll let her know you guys are back.
So y'all have reached an agreement?
We have, Your Honor.
All right, let's put it on the record.
Yes, Your Honor. So what we are agreeing to at this point in a full and final settlement agreement, which I will revise our partial settlement agreement tomorrow, send that back to Mr. Meinke for their execution. We'll get it executed and filed. Mr. James will have primary physical custody. He will have final decision-making authority. Visitation will be at the child's discretion. So that leaves the door open that if the child wants to have visitation with mom, that's a possibility. But we also reserve the issue of attorney's fees and guardian fees. We have agreed that both parties will pay their own attorney's fees. The guardian fees were already ordered to be split a specific way. It's going to stay that way. And my understanding from Ms. White is that the parties have plenty of money in trust and may actually get a bit of a refund once this is concluded.
Okay.
So I will revise that agreement tomorrow and get that to Mr. Meinke first thing in the morning.
All right. And then the full will be to me at what point?
Your Honor, I will have it to him tomorrow, so I'm not sure how quickly he can have this. James sign it. I know my client will be out of town for a couple days. As soon as he gets back, I'll have him execute it. So my hope would be by the end of next week, he will have all of the filed settlement agreement. We already have the child support addendum completed that my client will sign as soon as he's able to do so, since he'll be out of town. And then we should be able to have everything to you by the end of next week.
The end of next week?
Just because he's out of town, how quickly I can get him in the office to execute everything, since he's got to have everything notarized after I get it back from Mr. Meinke.
Yeah, but you said he's he's this week. Okay. Essentially, what's the day? Is Tuesday. Close the business next Tuesday. That's the time frame.
Sounds good, Your Honor.
Okay. And are there any outstanding fees for Ms. White? Wasn't there?
No, Your Honor. She indicated to me that she's holding funds in trust that would cover the remaining balance, so that the parties may actually receive a refund from her office.
Oh, from her. Okay.
Yes, Your Honor.
Okay. And let's see. It said all outstanding motions. Oh, motion for psychological notes. We, of course, that's resolved. That's moved now. Okay. Then I think that's it. All right. Thank you.
Yes, Your Honor. And would you like me to include in the agreement that, or in the final order, that all outstanding motions are resolved based on the agreement, just to make sure the record's very clear that those motions, since there aren't specific orders for each of them?
Yes, you can do that.
Thank you, Your Honor.
That's correct, Judge. That's our agreement.
All right. Sounds good. Thanks so much.
Thank you, Your Honor.
Thank you for your time, Your Honor.
You're welcome. Bye-bye. I'll take care.
Likewise.